7. Testing Justice 6. Testing Justice 5. Testing Justice 4. Testing Justice 3. Testing Justice. Testing Appellant Lavalier. Testing Appellee Lavalier.
The matter before the court is Cumberland 2414, Allrig USA Acquisitions versus MBD Realty. I see counselor present. If you would identify yourselves by saying your names for the record, together with the party you represent, starting with the appellant.
Good morning, Your Honor. Adam Chubb for the appellant, Allrig USA Acquisitions.
Good morning, Your Honors. James Monteleone for the appellee, MBD Realty, LLC.
Thank you. We are being streamed live on the web, both by audio and by video. And Mr. Shubb, if you are ready to proceed, we'd be happy to hear your argument.
Much appreciated, and good morning. May it please the court, Adam Chubb on behalf of the appellant, Allrig USA Acquisitions. This is a case where Allrig agreed to buy the site of the old Denny's in Portland near I-295 for $2.5 million. Allrig made a series of deposits along the way that ultimately totaled $170,000, only to come to find out before closing that the property was subject to a potential taking. At that point, Allrig sought to terminate the purchase and sale agreement and recover its deposit. MBD refused, and as the court knows, this claim was filed. There's 2 counts in this complaint, and with respect to the breach of contract claim, Allrig would concede that it is reasonable to interpret the non-refundability provision for the deposit broadly, which the trial court did in its dismissal order. However, it was inappropriate to dismiss the claim because it was also reasonable to interpret that provision only to apply to the specific contingencies that were referenced in the First Amendment, which was the title review and which was also the due diligence review. Nothing in that amendment states that all contingencies were waived, and specifically with respect to Section 16, which deals with eminent domain, that's not a provision in the purchase and sale agreement that's triggered on any timeline. Right up until the day of closing, if the purchaser were to find out that the property was subject to a taking, then they would have the right to terminate. It's not an affirmative obligation within the agreement the way title review is or due diligence review is, that have specific time periods, otherwise those rights are waived. With respect to the fraud claim, in our view, the facts that pled were sufficient to support a case for active concealment.
Can I ask a question about the fraud claim, following up on that? Is the allegation that the defendant had some kind of inside information, or is it just information that, frankly, anyone paying attention to the news or something like that would have, that you're alleging was concealed? In other words, it's really the intent that the city's going to take this for a roundabout.
Yes, Your Honor. It's not the allegation that this was proprietary or confidential information that that MBD was holding. It's simply material information that the seller knew and the buyer didn't know. Now, the buyer was an out-of-state buyer, developer. But
can it be the basis of a fraud claim? In other words, if I read something in the newspaper and don't tell you about it, you could have read the same newspaper. How is that possibly the basis for a fraud claim, even if I had an obligation to disclose information to
Well,
you?
it could be the basis for a fraud claim, Your Honor, to the extent that it's material information that the seller knows would inform the decision-making process for the purchaser as to whether they wanted to move forward. We know it's material information because it's something that's referenced in the purchase and sale agreement.
Well, it may be material, but it hasn't been concealed. It's basically something that they know that might be a factor that might affect the buyer's purchase, and something that the buyer would, in due diligence, would find out on their own. But if we accept your rule, it basically says to anybody contracting with a sophisticated person saying, oh, by the way, you might not want to enter into this contract because I know this thing that's out there that maybe you haven't discovered yet. That's the rule you're advocating for.
Well, I think the rule that we're advocating for is if a seller purposefully doesn't disclose material information, Your Honor, then it could support a sufficient allegation to move forward from 12b-6 to try to pursue a fraudulent concealment claim. It's not different than the Fitzgerald case. In the Fitzgerald case, the only fact that happened prior to the purchase and sale agreement and in the inspection period in that case was that the sellers didn't tell the buyers that the water wasn't safe to drink.
Well, there was more than that. They were hooked up to the neighbor's well. Also, that is not information that was equally as discoverable necessarily by the buyer as it was by the seller when you've got during the period under the purchase and sale a different water source.
Correct, Your Honor, but the hookup to the water and the testing happened just a couple of days before closing in the Fitzgerald case. When the buyers in that case were bound to the purchase and sale agreement, and to the extent they had an inspection period, those efforts, if you will, to conceal what had been going on hadn't even been taken yet. So when they were bound to the agreement, the only fact that was apparent at the time was that the sellers didn't disclose that the water wasn't safe to drink.
Counsel, would this fact have been revealable, discoverable in the ordinary course of due diligence? If it were, why did your client waive?
I'm sorry, Your Honor, could you repeat the question? I couldn't hear you.
If the city's plan to make adjustments to this neighborhood for a roundabout that would affect your client's acquisition, that were discoverable in the course of ordinary due diligence, would it have been discoverable if your client had conducted due diligence? And if so, why did they waive due diligence?
Well, the due diligence goes, Your Honor, to the conditions of the property, right? Sending somebody out there to check survey lines, sending somebody out there to check utilities.
Zoning regulations?
Zoning would be an issue, but I would submit to the court that our folks did find out, and they found out before closing when they went to City Hall and they learned for themselves that it was subject to an eminent domain. And that was a specific provision in the purchase and sale agreement that allowed for them to terminate and ask for their deposit back. So I think that the typical due diligence review is something that's completely separate and apart from determining whether there's an eminent domain or a taking that's afoot, which is why it's a separate provision. It's a separate provision in the agreement.
The contract in this case does contain, and I'm referring to paragraph 16, page 25 of the appendix. In the last sentence, it says, quote, seller and purchaser each agree to forward promptly to the other any notice of intent received pertaining to a taking of all or a portion of the property, end of quote. Doesn't that define the duty of disclosure in this case? In other words, why would there be a duty to disclose on MBD's part anything short of a notice of intent to take?
Well, I think both obligations can coexist, Your Honor. This, as you point out, specifically states that if there's a notice of intent, then one side has to provide it to the other. I don't think that also means that if they have material information specific to an issue they know is important to the purchaser, that they can just hold that back and then hope to get through.
But why doesn't the agreement say that?
I mean, I suppose it could, Your Honor. I just don't think that obviates any obligation on the part of the seller to say to have information and then not disclose it. But one other point I might add, in the Fitzgerald case and in the Keyser case, those cases all had the benefit of discovery. Here, it's very important, as the court knows, the procedural stage that we're talking about is the 12B6 stage. So we don't know what the folks at MBD did with the information, whether there were discussions inside MBD about, is this something we should tell the buyer? Is this something we should not tell the buyer? We don't know that in the Keyser case.
But the reason it was dismissed on 12b6 in this case is that there's, regardless of the answer to those questions, the court was saying, the trial court basically said, but there was no duty to disclose whatever that information was.
Well, yes, they did, Your Honor, but I think that that's separate from the active concealment piece, right? I think we've acknowledged that there was no fiduciary relationship.
So what was the active concealment here? Okay, so they knew it and they did nothing. That sounds passive, not active.
Your Honor, the allegation that they knew about it and did nothing, in our view, is enough to get us
How does
through.
that make it active?
Well, it's a term of art, and I think that the court has said in the Fitzgerald case and the Keyser case that it would be took some steps to conceal the information.
So if you
And-
know something that you think might affect whether the other side of a contract wants to go ahead, you have a duty to tell the other side. You're saying caveat emptor is dead in Maine.
No, Your Honor, we're saying that in this case, the seller knew that this was information that was material to the buyer.
Okay, so it's not, I'm thinking he might be interested. If you know that he's he'd be interested in knowing this.
This is something that would be important for the purchaser to know to inform their decision about what they want to go forward. I mean, we're talking about a redevelopment of the rotary right next to the
But you're
property.
still backing up into a passive, you know the information, and you know it's really important. We're still on the duty, what's the duty?
And Fitzgerald and Keyser both referred to tangible steps to conceal the thing, whatever it is, to hide it, to take it out of, and it's something that was uniquely known to the party, and they took affirmative active steps. Now here, this is something that's not uniquely known to the party. It's out there in the public. If you went to the city office and said, anything in this neighborhood we should be aware of, yeah, we're going to put a rotary in. Isn't it fundamentally different?
I don't think it's fundamentally different, Your Honor, and our folks did discover that when they had the meeting with City Hall. I would just direct the court, as I'm sure the court's reviewed already, it's page 1069 of the opinion, where the Fitzgerald court actually engages in the analysis of why they find that there is active concealment. There's nothing in that analytical paragraph, which begins with here based on the evidence submitted, that talks about any of the hooking up the well or anything that might be quote unquote.
But aren't you really basically fundamentally disagreeing with how the facts were handled in that case? I mean, you agree that in the case we didn't back away from the proposition that there had to be active concealment.
Of course not. We're not suggesting that that's not the standard or there doesn't need to be active concealment. The case that we're making today is it is enough at the pleading stage on a notice pleading standard for a buyer to allege the seller knew this information, they knew that it was important to the purchaser, and they purposefully held it back.
In the 45 seconds you have remaining, can you just address what is the nature, do you claim there's a duty to disclose here, a legal duty to disclose?
In this particular circumstance,
in
Your
this
Honor,
circumstance.
yes.
And what is the nature, what is the source of that duty? Just the fact that they knew it?
Yes.
Okay.
Yes.
There don't appear to be additional questions.
Thank you very much.
Thank you. Attorney Monteleone.
May it please the court. The Superior Court's dismissal of Allrig's breach of contract claim should be affirmed because no breach occurred. The signed contract addendum expressly waived the buyer's right to a refund of its deposit upon termination for any reason other than a seller's default per Section 12 of the original contract. It's undisputed that Allrig terminated the contract under Section 16, which related to eminent domain. Allrig does not contend that it terminated per Section 12. By the addendum's plain language, no refund was owed for a Section 16 termination. The Superior Court properly construed the contract at law because the language is unambiguous. Allrig's effort to craft a second interpretation is unavailing because the waived termination rights required no additional discussion about the deposit's disposition. Turning to the fraud claim, the Superior Court's dismissal should be affirmed because Allrig fails to establish two essential elements of active concealment. First, Allrig fails to allege any steps taken to hide the true state of affairs from Ulrich, a required element under this court's precedent case in Keyser v. Stimson. Second, Ulrich fails to establish justifiable reliance on the seller's omission of a material fact. The contract established that Ulrich expected no such disclosures and was solely responsible for its own independent investigations, including the timing or omission of public records reviews. Now, Ulrich contends that this court's earlier case of Fitzgerald v. Gamester stands for the proposition that a seller's silence alone can constitute steps taken to hide. But a viable claim for active concealment requires more. So there's two major problems with Ulrich's rereading of Fitzgerald. One, Fitzgerald did not involve mere silence, as the court has observed. The material omission at issue was that the water well had been abandoned. The Fitzgerald seller took affirmative steps to hide that prior abandonment by connecting to a neighbor's well and then reconnecting the contaminated well just before closing. Here, Ulrich's complaint asserts no such effort to hide. It alleges that MBD was aware that a public road project was planned, but does not allege either that MBD had knowledge that a taking was imminent or that MBD took any step to conceal the project. Two, Fitzgerald's material omission involves strictly private information about a water source that is unlikely to be ascertained but for the seller's disclosure. Here, the alleged omission was a matter of public record. Active concealment of such public record was impossible.
I want to make sure I understand your justifiable reliance argument. Are you saying that if a contract is unambiguous at not imposing any duty to disclose, that ipso facto there can't be a fraud claim?
There could be a fraud claim if there's justifiable reliance on the misrepresentation.
But you're saying it can never be justifiable reliance if there's no duty to disclose in the contract?
No, Your Honor. I think the important distinction about the reliance in this case relates to language in the contract that expressly acknowledged we're not receiving any kind of representation from you. We haven't received anything so far. We don't expect anything.
So it's the additional language in the contract, aside from the fact that it's imposing no duty, so there's no duty to disclose. But when they say we're not relying, you're saying how can there be fraud?
Or how can there be reliance, at least for that element?
Let's assume, though, with that contract language, let's assume that MBD really did have inside information that was not available to anyone else, and took active steps somehow to prevent Ulrich from finding that out. Are you suggesting that in those circumstances, the contract language would still mean that there could not be a claim for fraud?
Your Honor, I think the answer to that speculative question requires additional facts about the nature of the material omission. Because, for example, like the well in Fitzgerald, whether it was connected to the neighbor's water source or the property's water source was not something that an inspection could reasonably identify.
Okay, well, let's assume there was something like that in this property, okay? That it was something that was hidden by MBD and not disclosed, and not something that the buyer could reasonably be expected to discover. What I'm trying to get at is, are you suggesting that the language of the contract would prevent a fraud claim in that case?
No, Your Honor. The language of the contract strictly says the buyer is relying upon its own due diligence. For a fact that could not reasonably be discovered through due diligence, then there's no question the seller would if the seller is the only source to provide that information, as in the case of
So the language of not making representations and not relying on representations goes out the window in that instance?
Correct. If it can't, well, because the representations relate to independent due diligence, if it can be identified through independent due diligence, then one doesn't require representations. One doesn't expect representations.
Could this fact have been discovered in the course of regular due diligence?
Absolutely, Your Honor. This fact was discovered by Ulrich in the course of its regular due diligence. It just so happens that Ulrich didn't get around to conducting its public records review.
Suppose your client knew at the time that the Second Amendment was negotiated. Suppose your client knew that this fact existed, and it entered into the agreement knowing that and believing that the agreement would foreclose any refund of a deposit. Is that an active step?
No, Your Honor. It's not. Rather, actually, that fact scenario is consistent with the facts the First Circuit considered in the Pleasantville condominiums case, in which Phil was placed 20 years earlier, was deemed relevant, but the seller took no action whatsoever in the course of the sale to hide it, to make it like it wasn't so. It was a fact. The seller did nothing. And the First Circuit, relying upon this court's precedent in Keyser, recognized that that's not active concealment.
There is some reference in the materials somewhere that these parties are both sophisticated real estate operators. Is that a fact that is considered at all in this analysis?
Well, I think...
Is there a different standard for sophisticated real estate operators as opposed to a couple people who live in a neighborhood?
I believe there's not.
Okay.
However, there doesn't need to be. The functional issue here is that this is a commercial property. Now, there's a number of statutes that set forth particularized disclosure requirements relating to residential properties, trying to protect residential buyers that often are not on equal footing between the buyer and the seller. Such presumptions don't apply in the commercial setting. So the distinction between commercial and residential effectively achieves that purpose.
So the commercial parties are just left to the morals of the marketplace?
That's certainly what this court's precedent has long established in the context of buyer beware. A buyer is responsible to conduct his or her own due diligence and rely upon that due diligence. Matters that can be found in due diligence should be. In this case, it was. Now, this contract was entered into in February of 2022. It just so Ulrich was intended to complete its due diligence prior to June. When it didn't, it asked for more time. It didn't get around to identifying this public information until August. So this is simply a function of Ulrich's delayed timing, not a matter of concealment, because frankly, it's not something that Ulrich could have concealed. These records were created and maintained by the city of Portland. There's nothing that MBD can do to conceal that information from Ulrich.
I may have misunderstood the point you were suggesting that the fact that there were sophisticated parties involved in this particular transaction did it make a difference in terms of how the jurisprudence looked at this situation?
I don't believe it does make a difference.
Does that go to the level of the due diligence or the appropriateness of the due diligence that was or wasn't conducted by Ulrich?
I think the more important analysis is that the parties were on level footing when it came to contracting. The parties entered into these technical contract terms on level footing. It wasn't one party imposing terms that the other party may not understood, which was a factor that was suggested in Fitzgerald, for example, where there were no lawyers involved, there were no brokers involved, they just signed papers. In this case, both parties were on level footing, represented by counsel, represented by agents. Consequently, it's reasonable to hold Ulrich to the terms of the contract and its subsequent addendums that they signed. They had the opportunity to fully understand what was happening here. They had the opportunity to conduct due diligence, no differently than reviewing title at the Registry of Deeds.
Well, can I go to the language of the contract then? On the addendum, obviously your position is that paragraph 2 at the end, when it says effective as of the date hereof, the deposit, including all of the payments, shall be deemed non-refundable except in the event of a default by seller pursuant to section 12B, right? Your position is that that makes it non-refundable for all other purposes, right?
Correct, Your Honor.
So in reviewing the contract, it looks like the due diligence and title review under 5B was one of the circumstances under which there may have been a refundable deposit, right?
Correct?
12B, which is explicitly recognized, and as far as I can see, the only other place where there could have been a refundable deposit was indeed in paragraph 16, which is what was pulled in here, right? There's really no other clause where that would have come up.
Certainly, it's correct that there was a deposit refund clause in paragraph 16 originally. However, the express reference, the exception to paragraph 12 in the addendum, recognizes that the parties had the ability to identify and carve out the areas that they intended to exclude from application of the non-refundability provision.
But it doesn't say, and what I'm getting at is by that sentence, it seems to me that the only other paragraph that's being impacted is exactly the paragraph that was invoked here. In other words, paragraph 16, termination in the event of eminent domain, right? Or other force majeure, but.
I think the idea was that there are a number of different circumstances or contexts in the contract in which a right of refund might be expressed.
Well, there really aren't. That's my point. It seems like under 5B, and you've explicitly dealt with paragraph 5B here, 12B, and you're explicitly dealing with 12B, and you've just sort of left out the explicit reference to, I think, only really the one paragraph, which is 16, which is the paragraph under which the plaintiff terminated the contract. And so I find that a little curious that perhaps the language, your position is the language in the addendum is amending really only that one aspect when it talks about the non-refundability of the deposit.
Well, that's not correct, Your Honor. I mean, as the court observed, force majeure is another provision in which the party may have been entitled, at law to a refund of its deposit.
But isn't that also 16? That's my point.
Well, Your Honor, I think what's important is that the use of broad language saying any option but for paragraph 12. In other words, the deposit is non-refundable for under any basis but for paragraph 12. The parties clearly contemplated every other circumstance within the contract and opted to not provide additional exceptions to the non-refundability provision.
Was there a meeting of the minds on that? It appears that perhaps there wasn't.
I disagree, Your Honor. I think that the language recognizing that paragraph 12 retains its refund provision, no other paragraphs do, is expressly clear and can't be interpreted in any other way.
Mr. Shebb?
Yes, just briefly, Your Honor. The important issue on the contract claim is whether there are two reasonable interpretations of the amendment. And we submit, based on and consistent with your last line of questioning of counsel, that there are.
Well, let me flip to the other side,
Sure.
though. In the recital under the First Amendment, it says, whereas purchaser and seller desire to amend the agreement to deem the deposit unrefundable. I mean, that seems pretty clear.
It is, but the one little I in the hole says for waiving purchaser's due diligence and title review contingencies, which is also the same language that's found in paragraph 1, Your
Right,
Honor.
but neither are made in that whereas clause. Nothing was made dependent on the other, because 5 is such other changes as set forth herein. I mean, they're not dependent. They're saying these are the purposes.
But the amendment also has to be read in conjunction with the entire agreement, right? And what we know is that there was an extension payment that came before, which extended the inspection period. There was another amendment which kicked out the inspection period. So this was the third one. And this is the parties saying, finally, okay, we'll give you more time to close, but it's MBD saying we're not going to let you continue to do your due diligence and inspection, and that's fine.
Counsel, just to be clear, is a public records review part of due diligence?
A public records review with respect to zoning, could be considered part of due diligence, but it wouldn't eliminate Section 16, which is a separate right.
No, but it would fall directly under the first, it would fall directly under this amendment. You waive due diligence and you forfeit the deposit or anything that you could have found through due diligence.
But it wouldn't strike Section 16, Your Honor. Otherwise, if what you're saying is true, then Section 16 wouldn't be there to begin with, because whether someone was going to research eminent domain issues would be contemplated under their due diligence obligation. So I think that